Hello viewers, in this video I'll speak how to challenge Home Office visa refusal. Now, you can make an application to the Home Office with the hope, with an expectation to make that you will get it either leave to enter or leave to remain. However, in some time, the Home Office unreasonably, without merit, refuse your application. In this circumstance, what should you do? So, how you can challenge the Home Office refusal? Whether your application is eligible for appeal or your application is eligible for administrative review, or whether or the circumstance when your application is or your refusal is not eligible either of administrative review or judicial review. In this circumstance, what you should do, or even when your refusal is not even a appealable decision, for example, a visit visa application. So what you should do in this circumstance. Now, I'll give a brief idea about it, that what step you should do. Now, first step, what I do myself when I get a application for refusal. First things is I see the merit of the case. So I get the refusal letter. I assess the refusal, whether the caseworker, whether the anti-clearance officer made this decision according to law, whether he applied the correct policy, the correct immigration rules, correct case law, decision of the Supreme Court, decision of the ECHR, a decision of the higher court. So I assess the case and I put myself in the place of caseworker or a judge, and I think what I should do, what I would do if I in their place. And if I see there is a simple case working error and the decision is a point-based system or decision is eligible for administrative review, I'll apply for administrative review. And of course, if it is a good grounds, if it is a case working error, straight away you will get a decision. Now, the advantage of administrative review is less expensive and less time consuming. So you'll get the decision quicker and only £80 fees. So in administrative review, another caseworker, a senior caseworker, will assess your application again and he'll give a decision. Some of the application, which is you can't do appeal. Now, as you know, you can do appeal against a refusal is only human rights basis application, humanitarian protection application, and asylum claim. It used to be prior to 2014 Immigration Act, all decision is appealable. Now, following the 2014 Immigration Act, now only asylum claim and the human rights claim, humanitarian protection claim, you can do appeal. Again, is in-country or out-country right of appeal. This is a different matter, but at least you can do appeal this decision. Now, if you want to do appeal, then what I do first things I do is I again get the refusal letter, assess the case, review the decision, and see what the merit of the case. Because once you jump in the tribunal, in the court, it's expensive, it costs you. So before I jump that, I assess the case, so whether this case has a merit. When I see no, there is a good chance, and this document was missing when you submit the application, this document should be with the document. You should upload this document. You should cover this area. When you submit an application, you should write a cover letter or explain the law, the decision. For example, if you write a human rights basis application, you should mention what basis and which article you are applying, what are the case law, what is the guidelines, what is the decision of the Supreme Court with this regard, and accordingly give a well-structured guidelines for the caseworker, so that when the caseworker will read it, he will be impressed that to give you a positive decision. That is important for any types of human rights basis or asylum claim, whatever it is. Now, if I see, well, this was missed on the first application, so let me incorporate it and go to the appeal. So I'll make an application within 14 days, you need to submit appeal. If you are in the UK, if you're outside the UK, you should do it within 28 days. Now, if you can't do appeal against the decision, for example, or you can't do administrative review. Some, for example, a visit visa application. So a visit visa application, neither you can apply for administrative review, nor you can apply, you can go to court for to appeal against the refusal. So what are the remedy available? The remedy available is, if in case, if the visit visa application, if you find, again I do the merit, because in visit visa application most of the refusal is very unreasonable. They just refuse because they think it is, they apply for their discretionary power, and they said, well, I don't think you are a genuine visitor, you will return back to your home country. On that ground, they just refuse the application. So if this is to be the case, if the caseworker, if I see they didn't take into account the evidence you have submitted with the application, I will straight away apply, go to the judicial review route. And the process is, first, again, there is two steps. First step is three steps. The first step in judicial review, I issue pre-action protocol letter. Majority cases, from my experience, whatever cases I took the judicial review, 80% cases, 80% my application, what the home office basically reconsidered the decision again. So what I did, I issued the pre-action protocol letter explaining the law, explaining the circumstance of the applicant, explaining explaining the caseworker failed to consider the evidence which was submitted in respect of the circumstance of the visitor, of the applicant, and what is the law is, what the human rights law is. Yes, visiting family, friends is a human rights, and there are lots of decision of the High Court, Supreme Court, where it says is to maintain the connection, tie with the family is a human rights as well. So you need to explain it in the judicial review. You need to consider, you need to explain in a legal way to establish that the refusal was unreasonable. Now, in pre-action protocol, you must give the grounds. There are 5 grounds: unreasonable, irrationality, breach of not according to law. So all this principle you need to explain it, that the decision was the discretion applied unreasonably, and the refusal was unreasonable because of this, because of the evidence was not taken into account, because human rights was not taken into account, because caseworker was wrong. And how was wrong? So you need to explain it, and you need to provide again all the evidence, any further evidence, add to the pre-action protocol letter. Majority cases, especially in visit visa application, the Home Office will say, well, we will reconsider your application and will give you appropriate remedy. Therefore, it is not necessary to go to the judicial review, and you'll get a positive decision in the stage of reconsideration. So this is a judicial review. If the pre-action protocol doesn't come positive, then the next step is you need to go to the High Court or an upper tribunal, apply for judicial review. You need to fill up the form and submit the application, pay the court fee for permission to bring for judicial review. And then once permission granted, you will go to the full substantial hearing. So this is the process. Now, again, when you go to the because pre-action protocol is less expensive. Again, this is a very good idea to challenge Home Office refusal. If it is unreasonable, unlawful, or irrational, then you can go to the court. Challenge before go to the through the pre-action protocol. You can within a short period of time, you'll get a remedy from the Home Office. Then next step, go to the court. Again, before go to the before make the application to the upper tribunal. Again, assess the merit of the case. Speak to another lawyer or speak to another solicitor, another barrister, counsel, and assess whether it is worth to go to the court to get a decision. Again, if you get expert opinion, if it's a positive opinion, go to the judicial review, challenge the Home Office decision of unreasonable refusal. So I spoke about administrative review, I spoke about judicial review, I spoke about appeal. Appeal you can do only where appeal is available, and the refusal letter will give you an indication whether you can appeal to the faster tribunal or not, or whether you can go to the administrative review or not. If is indicate nothing, or if your decision is, ask a lawyer if your decision is not eligible for administrative review, or if it is not eligible for appeal, the option is judicial review. So none of the home office decision, whether it's a skilled worker refusal, whether it's a visit visa refusal, whether it's human rights application, whether it's LM claim, that you can left it, I don't have any remedy, I don't know. You have the remedy. You can challenge it by an independent judge, whether by your judicial review or by a faster tribunal, and appeal to the court. If you can go to the court tribunal and go there again, if the outcome of the administrative review come positive, or if the administrative review outcome of the administrative review come again same as first decision, again, what are the remedy? Again, if you can go to the tribunal again to challenge the decision of the administrative review, same process as the first refusal. Within 14 days, you need to go to the you need to submit the appeal to the faster tribunal. And then if you are outside the UK, you need to go within 28 days. So I was speaking about how to challenge home office decision, home office refusal decision. There are three ways you can challenge the home office decision. One is you can go to the administrative review. The second one, you can do appeal if the decision is eligible for appeal. If your decision not eligible for appeal or administrative review, you can go to the upper tribunal by your judicial review. Now, before you go to the tribunal for judicial review, you need to issue a brief.